Here to help us understand what this means for access to the drug in our area is Cora Trufrost. She's a professor at the Syracuse University College of Law, specializing in human rights law. Thank you so much for joining us.
Good morning. Thank you.
Now, for people in the tri-state area, we might assume that a ruling from a judge in Texas doesn't impact us, but that's not correct in this case. Can you explain the power this federal judge has?
Well, unfortunately, as you say, the judge in Texas is a federal judge, and his ruling has nationwide effect. And it is a ruling on challenge to a federal agency's authority. And so it's also worth pausing for a moment. While the immediate subject is abortion and access to abortion, the implications of this ruling could be much broader in many other agency areas. The significance for New York State residents is intense.
What is the Supreme Court deciding today?
So the Supreme Court has granted an emergency application. They aren't required to do so, but they did, I think, because of the dueling decision from the Washington Federal District Court that said that the FDA must allow access to mifepristone in 17 states and the District of Columbia. So basically what happens today will determine in the short term whether mifepristone is available on the market, and it will depend on the scope of the Supreme Court's ruling.
If the Supreme Court upholds the ban on the drug, can individual states pass legislation to protect access to the drug similar to what they did after Roe v. Wade was overturned?
This is what's interesting about this posture. In the case of Roe v. Wade being overturned by Dobbs, the Supreme Court was removing a constitutional protection, basically a floor that all states were required to give. And part of the rationale was that states should be able to legislate their own local values regarding reproductive freedom. So different states could do what they saw fit for a woman's access to reproductive freedom. This ruling from the court in Texas would have effect on all states regarding access to this particular drug. That's not to say, and there's really not much that that we could do legally to challenge except launch another request for the FDA to approve mifepristone, which would be a long process. So if the Supreme Court rules to uphold this stay, there isn't much to do about that drug. That's not to say that states are powerless. Governor Hochul has already called for stockpiling the companion drug, misoprostol, which and to authorize using it off-label. Off-label in this case would mean not in conjunction with mifepristone. And she's also taken a few other steps to try to ease access within New York State. Those are the types of actions, political actions, that state governors and state legislatures might take. The state's attorneys general are those who brought the suit in Washington state. And so perhaps there will be continued efforts to challenge the FDA process.
While anti-abortion activists see this ruling as a win, pro-choice activists likely want to challenge the ruling. What legal options do they have?
So the options are limited, as I said. If we end up, if they focus on this particular drug, which is the predominant drug, as your intro indicated, and has been in use for 20 years and quite safely, and so the possibilities are limited, and we'll see what transpires. It will be near chaos, I think, if this is upheld, because as I said in my first response, the implications of a ruling that a judge can strike down the judgment of scientists who have ruled that the drug is effective are that judges can intervene in administrative agency determinations generally, and it will be they who decide whether a drug is effective, not scientists.
Professor Trufrost, thank you so much for joining us.
My pleasure.